That's enough for today.
I want to make one comment, which I have been pondering as to whether I ought to make it. But there's a story which is inapplicable to you, Judge Alito, so I think I can make it. And the question is always raised, who's behind a successful man? And the answer is a surprise mother-in-law. But you have negated that infrequently told story. So I want to thank you for your testimony today, and I want to thank my colleagues for what we are proceeding to do here. In accordance with our commitment, is to have a full, fair, and dignified hearing, and I think we're on the way. And these proceedings are being very broadly covered. Can't pick up the front page of any newspaper in America without seeing your smiling face, Judge. And in an era where the media is filled with criticism about the Congress, I think it's a good day for the United States Congress to have these proceedings, because people have been watching them and they see long hours, and they see seriousness, and they see important issues, and they see the kind of dignity which we have had here today. And I thank my colleagues, and I thank you, Judge Alito. And we will resume this hearing tomorrow morning at 9:30. Cool. Thank you, sir.
Have a good evening, Judge. Good evening. Thank you. I'll get a good night's sleep.
Kind of easy.
Thank you, Tom.
Now, a portion of yesterday's hearing as the nominee takes questions from Senators Cole and DeWine.
Thank you very much, Mr. Chairman. Judge Alito, we heard a lot of discussion yesterday about the proper role of the judge in our system. Some said that a judge should favor neither the, quote, big guy or the little guy, but simply apply the law and not make the law. Based on what you said yesterday, I believe that you would agree generally with this characterization. However, to me, it's not quite so simple. Just as no two umpires call the same game exactly, no two judges see a case in exactly the same way. Laws in the Constitution are often ambiguous and capable of many interpretations. Those interpretations are the result of judges with different judicial philosophies. Some judges have a more liberal judicial philosophy, while others are more conservative, and we're here trying to figure out what your judicial philosophy is. That's probably the principal point of this hearing. If the law were so simple, we would not have as many 5-4 decisions. It seems to me that many of the most fundamental protections of civil rights and civil liberties that we take for granted today, things such as school integration, principle of one person, one vote, the principle that the accused have a right to a lawyer in criminal cases, and the right of contraception, just to name a few, have come when judges have been willing to look beyond rigid legal doctrines that prevailed at the times of those rulings. The neutral approach, that of the judge just applying the law, is very often inadequate to ensure social progress, right historic wrongs, and protect civil liberties so essential to our democracy. So isn't it true, Judge Alito, that a neutral judge would never have reached these conclusions? In fact, for decades, courts did not reach these conclusions. So would you agree that these cases were rightly decided, number one, and required, number two, that judges apply a more expansive, imaginative view of the Constitution?
I think that the Constitution contains both some very specific provisions, and they are The job of understanding what the provision means and applying it to new factual situations that come up is relatively easy. The Constitution sets age limits, for example, for people who want to hold various federal offices, and there can't be much debate about what that means or how it applies. But it also contains some broad principles: no unreasonable searches and seizures, the guarantee that nobody will be deprived of life, liberty, or property without due process of law, equal protection of the laws. And in those instances, it is the job of the judiciary to try to understand the principle and apply it to the new situations that come before the judiciary. I think the judiciary has to do that in a neutral fashion. I think judges have to be wary about substituting their own preferences, their own policy judgments for those that are in the Constitution. But they have to identify the principle that is to be applied under these broader provisions of the Constitution and apply it. But I don't see that as being the same thing as the judges injecting his or her policy views or preferences or ideas about the direction in which the society should be moving into the decision-making process.
But these decisions to which I just referred pushed society into new directions. And they came about, didn't they, as a result of Supreme Court's willingness, to look at the Constitution in perhaps a different way, in a new way, and take a new approach and a new avenue, which is not entirely consistent with a neutral judge simply applying the law. The law is the law. It's not hard to find that out, as you somewhat suggested. If you're an umpire, a ball's a ball, a strike is a strike. I'm suggesting that it's, and I think I would like to hope you would agree, it's somewhat, if not a lot more complex and sophisticated. If it weren't true, we could have a lot of views here today. I think you're unique in many ways, and part of that is your complexity, your sophistication, your ability to look at the Constitution and, if necessary, see new meanings that weren't seen there before. Isn't that true?
Well, Senator, I would never say that it's an easy process. There are some easy cases, but there are a lot of very difficult cases. And once you've identified the principle, the job of applying it to particular cases is often not easy at all. But what the judge has to do is make sure that the judge is being true to the principle that is expressed in the Constitution and not to the judge's principle, not to some idea that the judge has. And sometimes this results in groundbreaking decisions. Sometimes that's because new issues come up. Sometimes it's because the principle that is embodied in a constitutional provision has long been neglected. That was certainly true with respect to the Equal Protection Clause. There was a long period between Plessy versus Ferguson and Brown versus Board of Education when the true meaning of the Equal Protection Clause was not recognized in the decisions of the Supreme Court. And when Brown was finally decided, that was not an instance of the court changing the meaning of the Equal Protection Clause. It was an instance of the court writing an incorrect interpretation that had prevailed for a long period of time.
Okay. Judge Alito, one of the ways you get at a person's judicial philosophy is to look at the people whom they admire. In an interview that you gave in 1988, you were asked about your thoughts about Judge Robert Bork's nomination, and you said, and I quote, "Judge Bork was one of the most outstanding nominees of this century," unquote. Many Americans do not share Judge Bork's narrow views about the Constitution, views that would undermine many of the rights that we now take for granted, Judge Alito. Judge Bork thought that Americans had no constitutional right to use contraception, saying, and I quote, "The right to procreate is not guaranteed explicitly or implicitly by the Constitution," unquote. Judge Bork thought minorities had no constitutional right to have their votes counted equally, saying that in guaranteeing one man, one vote, the court, quote, "stepped beyond its boundaries as an original matter," unquote. In 1981, Judge Bork called Roe versus Wade, quote, "an unconstitutional decision, serious and wholly unjustifiable usurpation of state legislative authority," unquote. In addition, he had an unreasonably broad view of executive power, claiming that a law requiring the president to obtain an order from a court before conducting surveillance in the United States and against U.S. citizens for foreign intelligence purposes was, quote, a thoroughly bad idea and almost certainly unconstitutional. Can we assume from your admiration of Judge Bork that you agree with some of these statements, or at least that you support some of these beliefs if you were sitting on the Supreme Court? Frankly, it's curious to me that someone like yourself would consider someone with his views to be, quote, one of the most outstanding nominees of this century.
Senator, when I made that statement in 1988, I was an appointee in the Reagan administration, and Judge Bork had been a nominee of the administration, and I had been a supporter of the nomination. And I don't think the statement goes beyond that. There are issues with respect to which I probably agree with Judge Bork, and there are a number of issues with which on which I disagree with him. And most of the things that you just mentioned are points on which I would disagree with him. I expressed my view about Griswold earlier this morning on the issue of reapportionment. As I sit here today in 2006, and I think that's what's most relevant, I think that the principle of one person, one vote is a fundamental part of our constitutional law. And I think it would be, I don't see any reason why it should be reexamined, and I don't know that anybody is asking for that to be done. Every legislative district in the country and every congressional district in the country has been reapportioned, has been redistricted numerous times in reliance on the principle of one person, one vote, and the old ways of organizing state legislatures have long been forgotten. So I think that's very well settled now in the constitutional law of our country. Under the Fourth Amendment, I have no question about the decision in United States versus United States District Court, which held, and I think that's what you were referring to, which held that a warrant is required for domestic security surveillance, and that was the decision that led to the enactment of the Foreign Intelligence Surveillance Act.
Of course, and I was only referring to, or trying to refer to, your quote with respect to him and the positions he held, which I suggested were at variance with the positions I thought you held, which you're affirming here in your answer. So that the quote you're pointing out was something you made as an employee of the Reagan administration?
I was, and that was in, I saw that quoted in the paper yesterday. I think that was in 1980.
Not necessarily expressing your own real views?
I was a supporter of the nominee of the administration, and he was the nominee of the administration. He was and is an accomplished scholar. He had contributed a great deal to constitutional debate with his writings, and but I don't agree with him on a number of issues, and I've mentioned you've hit some of the issues on which I would definitely disagree with him.
Very good. Judge Alito, in a document appended to your job application, you also wrote that, quote, I disagree strenuously with the usurpation by the judiciary of decision-making authority that should be exercised by branches of government responsible to the electorate, unquote. This statement is especially troubling given that elsewhere in this application you wrote, quote, I developed a deep interest in constitutional law motivated in large part by disagreement with Warren Court decisions, particularly in the areas of criminal procedure, Establishment Clause, and reapportionment. Judge Alito, what Warren Court cases were you specifically talking about? Miranda, one person, one vote, any of the privacy decisions? What in particular were you talking about?
Well, Senator, I'm happy to address that. The statement was made in that 1985 form, and of course that was written 20 years ago. And in the form, what I was doing was sort of outlining the development of my thinking about constitutional law, and I went so far as to go back to my college days, which were before, of course, I had even attended law school, much less practiced law or served as a judge. I mentioned some of the leading areas that were covered by decisions of the Warren Court, and the decisions of the Warren Court really stimulated my interest in constitutional law. And I mentioned a book that had been published at the time, Alexander Bickle's book, The Supreme Court and the Idea of Progress, which was probably the first book about what you might call constitutional theory that I had read, and he was someone who I think most people would describe as a liberal, but he was a critic of the Warren Court for a number of reasons. And he was a great proponent of judicial self-restraint, and that was the main point that I took from my pre-law school study of the Warren Court. I spoke a bit about the reapportionment decisions. I don't believe that in fact, I'm quite sure I never was opposed to the one-person, one-vote concept. I do recall quite clearly that my father's work at the time, working for the New Jersey legislature and working on reapportionment, had brought to my attention the question of just how far that principle of one person, one vote had to be taken in drawing legislative districts. The New Jersey legislature and many other legislatures at the time were trying to redraw their districts in accordance with Reynolds versus Sims, which set out the one person, one vote principle. But it wasn't clear how exactly equal the districts had to be in population. And in some of the late Warren Court decisions, the court seemed to suggest, did say so for congressional districts, that they had to be almost exactly equal in population. And this idea, if applied to the legislatures and to the New Jersey legislative plan, would have wiped the plan out, because there were population deviations which, although not very large, were much larger than the court had said they were going to tolerate in the case of congressional districts. And I do remember that quite specifically. Professor Bickel made the argument that the court had taken the one person, one vote principle too far, and I know my father had said that although he thought it was a good idea, the idea of trying to get the districts to be exactly equal in population, at the expense of looking at other factors such as the shape of the district and respecting county lines or municipal lines, was a bad idea.
Judge Alito, you stated in that same job application that one element of the conservative philosophy that you believed very strongly, quote, very strongly, was the, quote, legitimacy of a government role in protecting traditional values, unquote. What traditional values were you referring to? And who decides what is a, quote, traditional value?
Well, again, I'm trying to remember what I thought about that 20 years ago, and I'm trying to reconstruct it. I think a traditional value that I probably had in mind was the ability to live in peace and safety in your neighborhood. And that was a big issue during the time of the Warren Court, and it was still a big issue in 1985 when I wrote that statement, because that was a time of very high crime rates. I think that's a traditional value. I think the ability of people to raise a family and raise their children in accordance with their own beliefs is a traditional value. I think the ability to raise a family, raise children in a way that they're not only subjected to, they're spared physical threats, but also psychological threats that can come from elements in the atmosphere is a traditional value. I think that the ability to practice your own conscience is a traditional value. That's the best I can reconstruct it now, thinking back to 1985.
Very good. Judge Alito, in Casey, you argued that the requirement that a woman notify her husband did not impose an undue burden upon a woman. You reasoned in part that the number of married women who would seek an abortion without notifying their husbands would be rather small. In other words, only some women who would be affected. The majority in that case disagreed with you and stated, quote, whether the adversely affected group is but a small fraction of the universe of pregnant women desiring an abortion seems to us irrelevant to the issue, unquote. This disagreement begs the question, is a constitutional right any less of a right if only one person suffers a violation, or should greater value be placed on that right if a larger number of people have that right violated?
Trying to apply the undue burden test at that time to the provisions of the Pennsylvania statute that were before the court in Casey was extremely difficult. And I can really remember wrestling with the problem. And I took it very seriously, and I mentioned that in my opinion. And it presented some really difficult issues. Part of the problem was that the law just was not very clear at that time. The undue burden standard had been articulated by Justice O'Connor in several of her own opinions, and there were just a few hints in those opinions about what she meant by it. But what she said was that an undue burden consisted of an absolute obstacle or an extreme burden. Those may not be exact quotes, but they're pretty close. And she did say that it was insufficient to show simply that a regulation of abortion would inhibit some women from going forward and having an abortion. That was the information that was available in her opinions to try to understand what this test meant. And so then the question became, how do you apply that to the numerous provisions of the Pennsylvania statute that were before us? And it was a difficult task. The plaintiffs argued that all of the provisions constituted an undue burden, and when the case went to the Supreme Court, Justice Stevens agreed with that. He said they all were an undue burden. Things like a 24-hour waiting period, that was an undue burden because it would inhibit some women from having an abortion. An informed consent provision, Justice Stevens thought, and the plaintiffs argued, that would be an undue burden. The majority on my panel and the joint opinion on the Supreme Court found that most of the provisions of the statute did not amount to an undue burden. The 24-hour waiting period, the informed consent provision, and all of them. We disagreed on only one, and that was the provision regarding spousal notification with a safety valve provision there that no sort of notification was needed if the woman thought that providing the notification would present a threat of physical injury to her. And I wrestled with that issue, but based on the information that I had from Justice O'Connor's opinions, it seemed to me that this was not what she had in mind. Now, that turned out not to be a correct prediction about how she herself would apply the undue burden standard to that statutory provision, but that was the best I could do under the circumstances.
Judge Alito, in your 1985 job application memo again, you identified reapportionment as one of the three issues decided by the Warren Court with which you disagreed. You even stated that your disagreement was so strong that it was one of the reasons that you became a lawyer. Supreme Court's Warren Court decisions on this topic, of course, stood for the fundamental principle of one person, one vote, meaning as a matter of constitutional law that each person's vote must count equally and each electoral district must have the same population. These decisions were more than 20 years old by the time of your 1985 job application. And these decisions stand for a fundamental principle of democracy. By 1985, virtually no serious scholar or constitutional lawyer could be found to disagree with the principle that each person's vote should count equally. So what was your disagreement with the Warren Court's decisions on this issue, Judge Alito, in 1985? Isn't one person, one vote basic principle of democracy? Wasn't it in 1985?
Senator, I don't believe that I disagreed with the principle of one person, one vote in 1985. I was talking about how I got interested in constitutional law back in college, and I was certainly stimulated at that time by my consideration of the issue of one person, one vote. But the issue that troubled me toward the end of the Warren Court, and this was during the time when I was in college, was the question of how far this principle went when it came to drawing legislative districts. Did they have to be almost exactly equal in population in accordance with the last census, or were larger population variations permitted? In a case called Kirkpatrick versus Priesler and another one called Wells versus Rockefeller that were decided around 1969, which was right at the end of Chief Justice Warren's tenure on the Supreme Court, the court held that in the case of congressional districts, they had to be almost exactly equal in population. And as I said, my father was deeply involved in this. When the issue came up again in the context of congressional districting in Karcher versus Daggett, which was around 1985, that was the case where he had been an expert witness, and the court struck down the New Jersey congressional districting plan, even though the population variations were under 1%. Now, the court also later said that when you're talking about legislative districts, considerably larger deviations are allowed, and you can take into account municipal lines and county lines and things of that nature. But as of the time when I was in college, as of the time of the two cases that I mentioned, it seemed likely. A lot of people thought, and certainly I, as a college student, thought that the rule was going to be the same for congressional districts as it was for legislative districts, and that seemed to say that the districts would have to be almost exactly equal in population based on the last census. Now, a problem with that is that while the census is very accurate, it's not perfect, and it doesn't stay accurate throughout the 10-year period from census to census. People move around, population grows, population diminishes in certain areas. So it didn't seem to make a whole lot of sense, let's say, in the middle of a decade, to insist on absolute population equality based on the last previous census, when everybody knew that the census figures had changed. And in doing that, insisting on practically equal population districts, districts of almost exactly equal population, you disregard municipal lines, you disregard county lines. People don't know which district they're going to be voting in. You introduce the possibility of other factors figuring into the districting plan.
Right. Okay. Family and Medical Leave Act, Judge Alito. In my view, one of the most important pieces of social legislation enacted in the last two decades was the Family and Medical Leave Act in 1993. Among other things, it gives employees the right to take up to 12 weeks of unpaid leave to care for a newborn child or an ill parent or a spouse. The statute also gives an employee the right to sue his or her employer for damages if the employer violates the employee's rights under this law. I was disturbed to learn that in the Chittister case, Judge Alito, your ruling denied a state employee the ability to sue his employer for money damages. Your reasoning was directly repudiated by the 2003 Supreme Court decisions of Nevada Department of Human Resources versus Hibbs. In that case, the Supreme Court, in a decision written by Chief Justice Rehnquist, held that the Family Medical Leave Act was congruent and proportional to Congress's interest in preventing discrimination based on gender, and therefore states could be sued for money damages under the law. So we're concerned that your view shows a lack of understanding of the problems of ordinary working Americans, the right of women to be free of discrimination in the workplace. Isn't it true that under your view, potentially millions of working Americans would not get the protections that they rely on under the Family and Medical Leave Act? Judge Alito. Well,
Senator, I'm happy to address that, because I think there's been some confusion about what the issue was in Chittister and how it relates to the Supreme Court's decision in Nevada versus Hibbs. I mean, there are actually two entirely different provisions of the Family and Medical Leave Act. The provision that was at issue in my case was not the one in Hibbs, and at last count, 7 circuits had decided that issue, the issue that was before my court in Chittister, exactly the same way we did. I counted up the number of Court of Appeals judges who endorsed that position, and it's over 20. I think it's 22. And they include some of the most distinguished Court of Appeals judges in the country and judges who have been appointed by presidents of both parties. The issue in Hibbs had to do with a provision of the Family and Medical Leave Act that requires employers to provide employees with a certain amount of leave for the purpose of taking care of another family member. The provision, and that was the one that the Supreme Court addressed in the Hibbs case. The provision in the Chittister case is a provision that requires employers to give employees a certain amount of leave for personal illness. The standard that has to be applied here is the one the Supreme Court has set out, and it's a controversial standard, but as a lower court judge, it's the one I had to apply, and that was whether what was done was congruent and proportional to constitutional violations. What the court said in Hibbs was that there was a record of constitutional violations, and remember, here we're talking about the provision that has to do with leave to take care of another person, and what they said was that there were many instances in which employers, state employers, had plans that provided more leave for that purpose for women than for men. And the reason was because of a stereotype that if somebody in the family got sick, It would be the woman, not a man, who would have to take off from work to take care of that person. But the provision that was at issue in Chittister had to do with leave for one's own personal illness. And there was no record that employers give, and a man was objecting to this, and there was no record that state employers, or for that matter any other employers, had plans that provided more sick leave for men than for women, or that any stereotypes were involved in the situation. And so that was why I concluded, and the unanimous panel that I sat on concluded, and all of these 7 other circuits concluded that that provision did not satisfy the standard that the Supreme Court had established.
Good. Last question. Judge Alito, I understand that you're reluctant to comment on cases that you would likely have coming before you in the future. But I'd like to ask you a question about a case that the Supreme Court certainly will never see again. 2000 presidential election contest between President Bush and Vice President Gore. Many commentators see the Bush v. Gore decision as an example of judicial activism, an example of the judiciary improperly injecting itself into a political dispute. Indeed, it appears to many of us who've looked at your record that Bush v. Gore seems contrary to so many of the principles that you stand for, that the President has said you stand for when making your nomination. Talking about judicial restraint, not legislating from the bench, and of course respecting the rights of the states. So, Judge Alito, I'd like to ask you, was the Supreme Court correct to take this case in the first place?
Well, Senator, I think you're probably right, and I hope you're right that sort of issue doesn't come before the Supreme Court again. Some of the equal protection ground that the majority relied on in Bush versus Gore does involve principles that could come up in future elections and in future cases. But as to that particular case, my answer has to be I really don't know. I have not studied it in the way I would study a case that comes before me as a judge. And I would have to go through the whole judicial process.
That was a huge, huge case. And I would like to hope, and I would bet, that you thought about it an awful lot, because you are who you are. And I would like for you to give an opinion from the convictions of your heart. As a person who's very restrained with respect to judicial activism, this being a case of extreme judicial activism, were they correct in taking this case, in your opinion?
Well, there's the issue of whether they should take it and the issue of how it should be decided. And, Senator, my honest answer is I have not studied it in the way I would study the issue if it were to come before me as a judge. And that would require putting out of my mind any personal thoughts that I had on the matter and thinking about listening to all the arguments and reading the briefs and thinking about it in the way that I decide, in the way that I do when I decide legal issues that are before me as a judge. And that's the best answer I can give you to that question. It was obviously a very important and difficult and controversial case. And in a situation like that, the obligation of a judge all the more is to be restrained and not to go through the judicial decision-making process and only at the end of that reach a conclusion about the issue.
Thank you, Judge. Thank you, Mr. Chairman.
Thank you, Senator Kroll. Senator DeWine.
Thank you, Mr. Chairman. Judge, you've almost turned the corner here, so that's the good news. The bad news is this is just the first round. So, let me respond, if I could, Judge, to 3 things that I've heard so far during these hearings that have frankly disturbed me. First, I'm bothered by what I consider to be distortions of your record, really in an effort to make you look like something that you're not. I just read a very interesting article by Stuart Taylor from the National Journal about this issue. And I would like, Mr. Chairman, to make this a part of the record, this article, if I could. Mr. Taylor describes the opinions of a, quote, right-wing jurist. This judge has consistently ruled against minorities, striking down affirmative action programs, making it harder for victims of race and gender discrimination to vindicate their rights.
Senator DeWine, your unanimous consent request is granted.
Thank you, sir. This judge has struck down a federal law to protect kids from guns, ruled that state and local governments cannot be sued under the Fair Labor Standards Act, leaving 4.7 million workers without a remedy in court. This judge has immunized the president from suit, even when he illegally wiretaps political opponents. This judge approved a police officer's fatal shooting in the back of an unarmed 15-year-old African-American boy. Finally, this judge has called abortion, and I quote, morally repugnant, and declared Roe v. Wade to be on, quote, on a collision course with itself. Based on such a record, no right-thinking Democrat could ever support such a judge. But as Taylor tells us, this judge is none other than Sandra Day O'Connor. The same Sandra Day O'Connor who has been praised for the past few days as a model of moderation. Judge, the point Mr. Taylor made is clear. You can distort and misrepresent anyone's record. And that, I believe, unfortunately, is what some of your opponents are doing to you. It's unfair, it's inaccurate, and it's just flat out wrong. Second, I would like to respond to the allegation that you have not written an opinion in favor of plaintiff alleging race discrimination on the job. You did a very good job a moment ago when Senator Kyle was talking to you and describing some of these cases. I think the facts of these cases are what is particularly interesting. In Reynolds versus USX Corporation, you ruled that an African-American woman whose co-workers and supervisors regularly made racial and sexual slurs against her and denied her training opportunities was, in fact, entitled to $124,000 in damages and in attorney fees. Zuby versus AT&T Corporation, you dissented, arguing against a stringent limitations period which prevented a civil rights plaintiff from filing a claim, and your position was vindicated. You were vindicated by the United States Supreme Court unanimously a few years later. In Smith v. Davis, you disagreed with the district court, which had dismissed an African-American employee's claim of discrimination. Instead, you found that there was evidence to support a finding that the employer's stated reasons for firing the plaintiff were not genuine. In Gooseby v. Johnson & Johnson, you ruled that the plaintiff, an African-American woman, was entitled to a trial on her claims of employment discrimination because you found that there was evidence that the employer was treating white male employees differently than it was treating the plaintiff. There are more cases, as you've testified to, but I think we make the point. We would all be better off, and this process, Mr. Chairman, would be better off and it would be more instructive if we could evaluate your nomination, Judge, based on your full and complete record. And finally, let me add my 2 cents on this Vanguard issue. I'm going to take it from a little different perspective than has been done so far. To me, this is really a non-issue. In the so-called Vanguard lawsuit, 2 people were in a financial dispute. The plaintiff sued to force the defendant to turn over $170,000 held by him in some Vanguard accounts. The defendant went to court to prevent Vanguard from turning over the money. Now, while Vanguard was technically part of the suit and was technically a defendant, it wasn't really a defendant in any sense of the term that would be used by the public or understood by the public. It was not accused of any wrongdoing. It didn't stand to lose anything. The only question was whether Vanguard would transfer some of the funds it held for one person over to another. It was simply being asked, who do I pay the money to? Who do I give the money to? That's all Vanguard was being asked to do. So nothing in the classic sense of being a defendant. Nothing about this case could realistically have affected Vanguard as a company. let alone affected your mutual funds. It's a joke. It's ridiculous. It's absurd. And everybody on this panel knows that. Now, for the sake of the process, I hope we can put these issues behind us. This hearing is really our opportunity to fully and fairly evaluate your qualifications for the High Court and to get some idea about how you think as a judge, how you process things, what kind of a judge you will be on the United States Supreme Court. Now let me turn to the substance. Judge Alito, I want to turn to an issue that is very important to me. In a number of recent cases, the Supreme Court of this country has restricted congressional power in a way that I think is not required by the Constitution. In my opening statement, I mentioned the Supreme Court's decision in Board of Trustees versus Garrett, a 5-4 decision. To me, that case is the best example of this recent trend, and it's not a good trend, in my opinion. Garrett involved a woman who claimed that she had been discriminated against because she was disabled. She was employed by the state of Alabama, and she sued the state under the Americans with Disabilities Act. The Supreme Court threw out the suit, however, holding that Congress lacked the power to make the state subject to suit. Now, Judge, as I see it, the problem with Garrett is that the court ignored findings made by Congress. While we were considering the ADA, we held 13 hearings and even set up a task force that held hearings in every state in the Union, attended by more than 30,000 individuals. Based on these hearings, we found hundreds of examples of people with disabilities being discriminated against by the states and in employment decisions. Further, we found that, and I quote, 2/3 of all disabled Americans between the ages of 16 and 64 were not working at all, even though a large majority of them were capable of doing so. And finally, we found that this discrimination flowed from, and I quote, stereotypic assumptions about people with disabilities as well as, and I quote, purposeful unequal treatment, end of quote. Sadly, however, in Garrett, the court said that this was just not enough. In fact, it held that we had not pointed to any evidence that the states discriminated in employment decisions against people with disabilities. Judge Alito, from a review of your decisions, it appears to me that you tend to defer in close cases to the decisions of those individuals closest to the problem at hand. I applaud you for taking that approach. Now let me ask you, in your opinion, what role should a judge play when reviewing congressional fact-finding? And how can you assure us that you will show appropriate deference to the role of Congress as the representative of the people in this democracy when we pass important legislation?
I think that the judiciary should have great respect for findings of fact that are made by Congress. And in the Rybar decision that I was discussing earlier, although it is controversial and it involved an application of the Lopez decision, I stated that decision would have been very different. That case would have been very different for me if Congress had made findings. And that's because of two things. I am fully aware of the fact that the members of the judiciary are not the only officers in the United States who take an oath to support and defend the Constitution of the United States. The members of Congress take an oath to support the Constitution, and officers of the executive branch take an oath to support the Constitution, and I presume that they go about their work in good faith. The second point, and this goes directly to the issue of findings, is that the judiciary is not equipped at all to make findings about what's going on in the real world, not this sort of legislative findings. And Congress, of course, is in the best position to do that. You have constituents, members of Congress hear from their constituents. Congress can have hearings and examine complex social issues, hear testimony, receive statistical data, hear testimony from experts, analyze that and synthesize that and reduce that to findings. And when Congress makes findings on questions that have a bearing on the constitutionality of legislation, I think they are entitled to great respect.
Well, Judge, I appreciate your response. We can't ask you, obviously, to decide any particular case, but what we're trying to do today is get a general idea of how you approach cases, and we've looked at, as I said, looked at your previous cases. We have a pretty good idea from that, but I appreciate this exchange. Let me follow up with this. Garrett is the law of the land today. Nonetheless, let me ask you whether after Garrett, Congress might still have a way to protect the disabled. Rather than focus on the problem caused by Garrett, let me focus on the solution. To me, even after Garrett, Congress still has the power to protect the disabled under the spending clause of the Constitution. I'd like to explore maybe that with you if I could. Let me give you an example of how this might work. You're, of course, very familiar with South Dakota versus Dole. In that case, Congress had wanted to establish a national drinking age of 21. As you know, we, of course, don't have the power to require that under our Constitution. Therefore, Congress used its power under the spending clause. We said to the states, if you don't establish a 21-year-old drinking age, you will lose 5% of your federal highway dollars. This left the states with a choice: adopt a 21-year-old drinking age or lose 5% of their federal money. When presented with such a choice, the states kept the money and changed their drinking age to 21. It seems to me that Congress might be able to use this same approach to require the states to waive their immunity from suit under statutes like the ADA. Judge, based on your experience, could you give me your understanding of what Congress can do and what it can't do under its spending clause power? Maybe just go back and look at some recent cases and give me a little.
Yes, certainly, Senator. Well, I think you've pointed to the leading case in this area, and that's South Dakota versus Dole. And South Dakota versus Dole recognizes that Congress has broad powers under the spending clause, and that when Congress provides money to the states, Congress can attach conditions to that money, to the receipt of the money, provided that certain standards are met. One thing that has to be done under the Supreme Court's cases is that there has to be a clear statement that the conditions are attached to the receipt of the money. The Supreme Court views this like a contract, so that the parties need to have, the party receiving the notice has to have clear and fair notice about what it's agreeing to by taking the money. And then beyond that, the condition, if that's satisfied, then the condition has to be germane to the purposes of the funds. And in South Dakota versus Dole, the court found that the drinking age and the 55-mile-an-hour speed limit were germane to the purpose of the expenditures, and these, I believe, were federal highway funds. So those are the standards that would be applied to any future legislation under the current precedents if the future legislation invokes Congress's broad power under the spending clause.
That's helpful. Thank you, Judge. During the confirmation hearing of Chief Justice Roberts, Chairman Specter showed us a chart stating that the Supreme Court had the opportunity to overrule Roe v. Wade in 38 cases. Because of this, the chairman suggested that Roe was not only super precedent, but super duper precedent. Chairman has made the same argument at the hearing today. In fact, he brought the chart out again today. Now, Judge, just to show you that not all members of this panel are like-minded, I want to tell you that I disagree. To me, Roe is not super precedent. I believe Roe is precedent, but I don't believe it's super duper precedent nor super precedent. First, although the court has applied Roe in 38 cases, it has not directly taken up the issue of whether to overrule Roe in every one of those cases. In fact, out of those 38 cases, I've only found 4 in which the court directly addressed the status of Roe as binding precedent. In Webster, the court asked whether Roe should be reaffirmed, but ultimately avoided the issue. In 3 cases, City of Akron, Thornburg, and Casey, the court did reaffirm Roe. But the last of these cases did so in a way that hardly left Roe on firm footing. In fact, Casey altered Roe by eliminating the strict scrutiny standard of review and replacing it with a lesser undue burden test. The result has been that many restrictions on abortion have been upheld. Second, just because Roe has been applied and reaffirmed does not make it a special form of precedent. Many other cases have been applied for decades before eventually being overruled. For example, Plessy versus Ferguson. The case establishing the principle of separate but equal was upheld for nearly 60 years before it was overruled, and certainly discredited today. Lochner versus New York, a case that greatly limited the power of the states to protect children and workers, was consistently applied for more than 30 years before it was overruled. And Swift versus Tyson, the case establishing the doctrine of federal common law, was a bedrock principle of American law, repeatedly applied and upheld for nearly 100 years before it, too, was struck down. Thus, the mere fact that Roe has been upheld for more than 30 years does not mean that it is entitled to special deference. Third, from the start, Roe has been criticized by lawyers, scholars, and judges, whether Democrats or Republicans, and to date it does remain controversial. Fourth, much has happened over the last 30 years to undermine the soundness of Roe. Senator Brownback has mentioned how the facts of Roe have changed. We now know that the plaintiff in Roe based her case on false statements and that she wants the case overturned. We also know much about the life of babies in utero that we did not know 30 years ago. We even know something about the internal deliberations of the justices who decided Roe. In an internal Supreme Court memo, Justice Harry Blackmun, the author of Roe, acknowledged that the trimester framework established in his opinion was, and I quote, arbitrary. And Justice Lewis Powell said that he could not find a right to an abortion within the Constitution and decided instead to rely on his gut. Finally, whatever the term precedent, super precedent means, I do not think that it describes Roe. In an article by William Landis and Richard Posner, super precedent was defined this way. It is a, and I quote, precedent that is so effective in defining the requirements of the law that it prevents legal decisions arising in the first place, or, if they do arise, induces them to be settled without litigation, end of quote. In other words, super precedent is precedent that is so firmly entrenched in our legal system that people simply don't question it. Marbury versus Madison, the case establishing the power of judicial review, is super precedent. It is so well settled that litigants do not challenge it in court. In fact, it is one of the fundamental assumptions upon which our constitutional system is built. Roe is hardly Marbury. Is Roe Supreme Court precedent? Certainly. But in my view, it is not super precedent or even, it is not super duper precedent or even super precedent. It is precedent, nothing more. Judge, I want to turn now to another topic, to an issue that several federal judges in Ohio have brought up to me during our conversations. As you know, the Supreme Court currently decides about 75 cases a term. This number is down dramatically from where it was just a generation ago. 1976, for example, the court decided almost 400 cases on the merits, more than 5 times what it does today. This incredible shrinking Supreme Court docket has been the focus of much attention over the past few years, a lot of discussion. And one result of the court deciding fewer and fewer cases is that more and more circuit splits are left unresolved, which is what I want to talk to you about. As we all know, a circuit split occurs when 2 or more federal courts of appeals disagree on an issue of federal law. As of late, circuit splits have become so pervasive that the Seton Hall Law School came out last year with a new law review dedicated exclusively to that issue. There is also a website written by a law professor at the University of Richmond solely committed to identifying new circuit splits. Hardly a week passes when at least one does not emerge. To me, these pervasive and unaddressed circuit splits create three problems. One, organizations that transact business across state lines get caught in the crosshairs of this confusion, being subject to one interpretation of federal law in California and a different one in the state of Ohio. Second, federal judges are placed in a difficult situation of trying to figure out what the law requires. In fact, a number of federal judges in Ohio have talked to me, as I said, about this. And finally, circuit splits undermine the goal of having uniformity in our federal law. Let me just ask you, what is your opinion about this issue? In your experience, has the Supreme Court's shrinking docket caused problems for businesses, lower court judges, and individuals? Is there a problem with the number of unresolved circuit splits? And if the court takes more cases, do you think that will solve the problem?
Well, that's a difficult issue for me to address from my current position as a judge of the Court of Appeals, because the Supreme Court is my boss, and I am reluctant to suggest that I think they should be doubling their workload. That's not the sort of thing.
Go ahead.
That's not the sort of, or even increasing it at all. That's not the sort of thing that subordinates generally do regarding superiors. The issue, but circuit splits are certainly undesirable, and I think everybody recognizes that, and that's one of the grounds for granting certiorari. I know that when Justice White was on the court, he regularly would dissent from the denial of certiorari in cases where there was a circuit split, because he felt strongly that circuit splits should be resolved by the Supreme Court. I have friends, former colleagues from prior times in my career who are appellate attorneys who specialize in cases before the Supreme Court and in appellate litigation generally, and occasionally I hear them complain about unresolved circuit splits that are difficult for their clients, and so I'm aware of their complaints. I haven't personally kept track of the number of circuit splits that exist, but certainly they are an undesirable thing, and it is a ground for granting certiorari. And I think one of the jobs that the Supreme Court has is to iron out circuit splits. There can be disagreements about whether there really is a circuit split, obviously, in a particular case, and there can be differences of opinion about the timing for resolving circuit splits. Sometimes the Supreme Court thinks it's advisable to wait and see how an issue plays out in a number of circuits before the Supreme Court decides to take on the issue, and that may improve their ability to resolve the issue when the case eventually comes before them.
Well, Judge, let me just suggest that I think it's a problem, and I think the Supreme Court needs to deal with it. Chief Justice Roberts indicated that he thought the court could take on more, and I would suggest that they could. So I appreciate your comments. Judge Alito, let me ask you about Congress's power to protect our children from the proliferation of pornography on the Internet. This is an important issue. I raised it at the last hearing. It's one that I think is very troubling. Congress has tried several times to protect our children from being exposed to pornography on the Internet. In 1996, we passed the Communications Decency Act, but the Supreme Court struck it down, citing the First Amendment. A few years later, we passed the Child Online Protection Act. Again, the court struck it down. What bothers me about these cases is they fail to account for something that to me seems relatively simple. At the core of the First Amendment is the protection of political speech. But it seems to me that pornography is altogether different. Unlike political speech, pornography has very little value, if it has any value at all. It doesn't communicate a message other than one that degrades women. It does not contribute to the public debate, and actually causes harm to the victims who take part in making it and those who use it. There are, of course, a number of cases that seem to recognize that pornography is of lesser value speech. In Young versus American Mini Theaters, the court upheld zoning regulations on adult theaters. In doing so, Justice Stevens had this to say, and I quote, "Even though we recognize that the First Amendment will not tolerate the total suppression of erotic materials that have some arguably artistic value, It is manifest that society's interest in protecting this type of expression is of a wholly different and lesser magnitude than the interest in untrammeled political debate. Let me ask you, Judge, what is your thinking on this subject? Is pornography lesser value speech, as Justice Stevens has seemed to suggest, and are there or should there be different levels of speech under the First Amendment?
I think that the problem of protecting children from pornography on the Internet illustrates the fact that although the task of the judiciary is to apply principles that are in the Constitution and not make up its own principles, to apply those to different factual situations, when the world changes, and in particular when, in the First Amendment context, when means of communication changes, the job of applying the principles that have been worked out, and I think in this area worked out with a great deal of effort over a period of time in the pre-Internet world, applying those to the world of the Internet is a really difficult problem, and I understand that Congress has been struggling with it, and I know the judiciary has been struggling with it. The law, of course, as you know, constitutional law draws a distinction between obscenity, which has no First Amendment protection but is subject to a very strict definition, and pornography, which is not obscenity but is sexually related materials. With respect to minors, the Supreme Court has said that it's permissible for a state to regulate the sale of pornography to minors. It has greater authority there. I think that's the Ginsburg case. It has greater authority there than it does with respect to the distribution of pornography to adults. Now, in the pre-Internet world, the job of preventing minors from purchasing pornography was a lot simpler. If they wanted to get it, I guess they would have to go to a store or someplace and buy it. But on the Internet, of course, it's readily available from any computer terminal, and a lot of minors today are a lot more sophisticated in the use of computers than their parents. So the ability of parents to monitor what they're doing and supervise what they're doing is greatly impaired by this difference in computer aptitude. And I can't say much more about the question than that. It is a difficult question. I think that there needs to be additional effort in this area, probably by all branches of government, so that the law fully takes into account the differences regarding communication over the Internet and access to materials over the Internet by minors.
Judge, I have one last question. If confirmed, the Supreme Court, only part of your job will be hearing arguments and issuing opinions. An equally important part of the job will be involved deciding which cases to hear in the first place. Each year, the Supreme Court receives approximately 8,000 petitions for cert. Cert petitions, as they are called. These are petitions by a party to a lawsuit asking the court to hear its case. Out of these 8,000 annual requests, the court decides to hear only about 75 to 80. For many years, individual justices would review each cert petition and cast a vote on whether to hear the case. Today, however, 8 of the justices are part of what is called the cert pool. Here's how it works. All petitions are put into a pool. A single law clerk then picks up a petition and writes a memo recommending for or against hearing the case. That memo is then circulated to the 8 justices in the cert pool, who use it to cast their vote on whether to hear the case. Justice Stevens is the only one who does not participate in this pool. Instead, he has his staff prepare a memo on each case with a recommendation tailored to his own thinking on an issue. It would seem to me that the cert pool greatly limits the exchange of ideas among members of the court. I wonder if you could tell me how you would intend to proceed, if you're going to use the pool or if you're going to do what Justice Stevens does, or if you've thought about it.
I'm aware of the issue, but I have not thought past what might happen with these confirmation proceedings. So it's not the kind of issue that I have really thought through in my mind. If I'm fortunate enough to be confirmed, I think I would assess the situation at that time and talk to the Supreme Court justices and see what their views are, the reasons why they're proceeding in one way or another. I know from my perspective as a lower court judge that there is a constant conflict between the obligation that we have to deal with a very heavy caseload and the need for the judge, as opposed to a law clerk or a staff employee of the court, to deal with the cases. We cannot delegate our judicial responsibility, but we do need to call on, we need to find ways, and we do find ways of using, of obtaining assistance from clerks and staff employees so that we can deal with the large caseload that we have.
Thank you, Judge.
Thank you, Senator.
Here you can see preparations for the second day of Samuel Alito's confirmation hearing. The Senate Judiciary Committee began the question phase yesterday, and we'll show you the first portion. After this, Washington Journal, then live coverage of Day 3 of the confirmation hearing.
The Judiciary Committee will now proceed with the confirmation hearing of Judge Alito for the Supreme Court. Before beginning the first round of questionings, just a little review as to our procedure. As announced, there will be a 30-minute allocation for each senator. We intend to work rather late this afternoon, perhaps even into the early evening. I don't know that it's possible to complete the first round of questioning today. That would be a good objective. We'll see how it goes. Judge Alito, you are free to let us know whenever you want to break. We will take a couple of breaks at the midpoint of the morning and the afternoon, but there are 18 of us and only one of you, so when you would like a break, your schedule takes precedence over ours. Before beginning the opening round, let me yield to my colleague, Senator Leahy, to see if he has some initial comments.
Well, thank you, Mr. Chairman. I also appreciate the fact we have kept to the clock. I think it has been helpful, and I would hope that the Judge Alito would bear with us on that. We will have a lot of questions. I think that take the time to get them all. You've always been accommodating that, and I think that that requires cooperation on both sides of the dais. We do have the advantage, Mr. Chairman, that we didn't have with Judge Roberts' hearings, that we're not in session. We're not going to be interrupted by votes, and we have the time to do it. I would hope that we don't go into a marathon for both his sake and us older guys' sake. But I do appreciate you've run this with fairness and equal-handedness, and I appreciate that.
Well, since there are no older guys involved or gals, we can consider the marathon, but we'll keep it within bounds. Okay, you can start the clock. I will maintain the clock meticulously as we have maintained timing in our Judiciary Committee practice. Judge Alito, you'll be faced with many questions on many topics. I'm going to start today with a woman's right to choose, move to executive power, and then hopefully within the 30 minutes pick up congressional power. Starting with the woman's right to choose, Judge Alito, do you accept the legal principles articulated in Griswold versus Connecticut that the Liberty Clause in the Constitution carries with it the right to privacy?
Senator, I do agree that the Constitution protects a right to privacy, and it protects the right to privacy in a number of ways. The Fourth Amendment certainly speaks to the right of privacy. People have a right to privacy in their homes and in their papers and in their persons, and the standard for whether something is a search is whether there's an invasion of a right to privacy, a legitimate expectation of privacy.
Well, Griswold dealt with the right to privacy on contraception for married women. You agree with that?
I agree that Griswold is now, I think, understood by the Supreme Court as based on the liberty clauses of the Due Process Clause of the Fifth Amendment and the 14th Amendment.
Would you agree also with Eisenstadt, which carried forward Griswold to single people?
I do agree with the result in Eisenstadt.
Let me move now to directly into Casey versus Planned Parenthood and picking up the gravamen of Casey as it has applied Roe on the woman's right to choose, originating from the Privacy Clause, with Griswold being its antecedent. And I want to take you through some of the specific language of Casey to see what your views are and what weight you would ascribe to this rationale as you would view the woman's right to choose. In Casey, the joint opinion said, quote, "People have ordered their thinking and lives around Roe. To eliminate the issue of reliance would be detrimental. For two decades of economic and social development, people have organized intimate relationships in reliance on the availability of abortion in the event contraception should fail. Pretty earthy language, but that's the Supreme Court's language. Then the court went on to say, quote, the ability of women to participate equally in the economic and social life of the nation has become facilitated by their ability to control their reproductive lives. Now, that states in specific terms the principle of reliance, which is one of the mainstays, if not the mainstay, on stare decisis, precedent to follow tradition. How would you weigh that consideration on the woman's right to choose?
Well, I think the doctrine of stare decisis is a very important doctrine. It's a fundamental part of our legal system, and it's the principle that that courts in general should follow their past precedents. And it's important for a variety of reasons. It's important because it limits the power of the judiciary. It's important because it protects reliance interests, and it's important because it reflects the view that courts should respect the judgments and the wisdom that are embodied in prior judicial decisions. It's not an inexorable command, but it is a general presumption that courts are going to follow prior precedents. And as you mentioned,
how do you come to grips with the specifics where the court, in the joint opinion, spoke of reliance on the availability of abortion in the event contraception should fail, on that specific concept of reliance?
Well, reliance is, as you mentioned, Mr. Chairman, one of the important foundations of the doctrine of stare decisis. It is intended to protect reliance interests, and people can rely on judicial decisions in a variety of ways. There can be concrete economic reliance. Government institutions can be built up in reliance on prior decisions. Practices of agencies and government officials can be molded based on reliance. People can rely on decisions in a variety of ways.
Let me move on to another important quotation out of Casey. Quote, a terrible price would be paid for overruling Casey, for overruling Roe. It would seriously weaken the court's capacity to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. To overrule Roe under fire would subvert the court's legitimacy. Do you see the legitimacy of the court being involved in the precedent of Casey?
Well, I think that the court and all the courts, the Supreme Court, my court, all of the federal courts, should be insulated from public opinion. They should do what the law requires in all instances. That's why the members of the judiciary are not elected. We have a basically democratic form of government, but the judiciary is not elected, and that's the reason, so that they don't do anything under fire. They do what the law requires.
But do you think there is as fundamental a concern as legitimacy of the court would be involved if Roe were to be overturned?
Well, Mr. Chairman, I think that the legitimacy of the court would be undermined in any case if the court made a decision based on its perception of public opinion. It should make its decisions based on the Constitution and the law. It should not sway in the wind of public opinion at any time.
Let me move to just the final quotation that I intend to raise from Casey, and it is, quote, after nearly 20 years of litigation in Roe's wake, we are satisfied that the immediate question is not the soundness of Roe's resolution of the issue, but the precedential force that must be accorded to its holding. That separates out the original soundness of Roe, which has been criticized, and then lays emphasis on the precedential value. How would you weigh that consideration were this issue to come before you, if confirmed?
Well, I agree that in every case in which there is a prior precedent, the first issue is the issue of stare decisis. And the presumption is that the court will follow its prior precedents. There needs to be a special justification for overruling a prior precedent.
Let me turn to an analogous situation, and that is Chief Justice Rehnquist's change of heart on the Miranda ruling. In 1974, in the case of Michigan versus Tucker, he was then Justice Rehnquist, wrote an opinion severely limiting Miranda, in effect saying he didn't like it. Then in the year 2000, in the case of United States versus Dickerson, Chief Justice Rehnquist wrote an opinion upholding Miranda. And he did that because, quote, Miranda was embedded in the routine police practices to a point where the warnings have become a part of our national culture, close quote. Now, there has been an analogy made from what Chief Justice Rehnquist said on the Miranda issue to the Roe issue. How would you evaluate the consideration of Roe's being embedded in the culture of our society?
I think that Chief Justice Rehnquist there was getting at a very important point.
Think he was right?
I think he was right in saying that reliance can take many forms. It can take a very specific and concrete form, and there can be reliance in the sense that he was talking about there. And I think what he's talking about there is that a great many people, and in that instance, police departments around the country over a long period of time, had adapted to the Miranda rule, had internalized it. I think that all the branches of government had become familiar with it and comfortable with it and had come to regard it as a good way, after a considerable breaking in period, a good way of dealing with a difficult problem. And the problem was how to deal with interrogations leading to confessions. And
Judge
so
Alito, let me move to the dissenting opinion by Justice Harlan in Poe versus Ullman, where he discusses the constitutional concept of liberty and says, quote, the traditions from which liberty developed, that tradition is a living thing. Would you agree with Justice Harlan that the Constitution embodies the concept of a living thing?
I think the Constitution is a living thing in the sense that matters, and that is that it sets up a framework of government and a protection of fundamental rights that we have lived under very successfully for 200 years. And the genius of it is that it is not terribly specific on certain things. It sets out some things are very specific, but it sets out some general principles and then leaves it for each generation to apply those to the particular factual situations that come up.
Would you agree with Cardozo and Palco that it represents the values of a changing society?
The liberty component of the Fifth Amendment and the 14th Amendment, which I was talking about earlier, embody the deeply rooted traditions of the country, and it's up to each. Those traditions and those rights apply to new factual situations that come up. As times change, new factual situations come up, and the principles have to be applied to those situations. The principles don't change. The Constitution itself doesn't change, but the factual situations change, and as new situations come up, the principles and the rights have to be applied to them.
Judge Alito, the commentators have characterized Casey as a super precedent. Judge Luttig, in the case of Richmond Medical Center, called the Casey decision super stare decisis. And in quoting from Casey, Judge Luttig pointed out the essential holding of Roe versus Wade should be retained and once again reaffirmed. And then, in support of Judge Luttig's conclusion that Casey was super stare decisis, he refers to Stenberg versus Carhart and quotes the Supreme Court saying, we shall not revisit these legal principles. Now, that's a pretty strong statement for the court to make, that we shall not revisit the principles upon which Roe was founded. And the concept of super stare decisis or super precedent arises, as the commentators have characterized it, by a number of different justices appointed by a number of different judges over a considerable period of time. Do you agree that Casey is a super precedent or super stare decisis, as Judge Luttig said?
Well, I personally would not get into categorizing precedents as super precedents or super duper precedents or any
You
sort
say
of,
super duper?
right, any sort of
Good.
categorization like that.
I like that.
It sort of reminds me of the size of laundry detergent in the supermarket. I agree with the underlying thought that that when a precedent is reaffirmed, that strengthens the precedent, and when the Supreme Court says that we are not
About
going
being
to
reaffirmed 38 times.
Well, I think that when a precedent is reaffirmed, each time it's reaffirmed, that is a factor that should be taken into account in making the judgment about stare decisis. And when a precedent is reaffirmed on the ground that stare decisis precludes our counsels against reexamination of the merits of the precedent, then I agree that that is a precedent on precedent. Now, I don't want to leave the impression that stare decisis is an inexorable command, because the Supreme Court has said that it is not. But it is a judgment that has to be based taking into account all of the factors that are relevant and that are set out in the Supreme Court's cases.
Judge Alito, during the confirmation hearing of Chief Justice Roberts, I displayed a chart. I don't ordinarily like charts, but this one I think has a lot of weight, because it lists all 38 cases which have been decided since Roe, where the Supreme Court of the United States had the opportunity to Senator Hatch is in the picture now. It's a good photo op for Senator Hatch. Senator Leahy's complaining
I just balance it on Oren's head.
he wants
that over by Leahy.
wants it on his side. Well, I think the point of it is that there have been so many cases, 15 after your statement in 1985 that I'm about to come to, and 8 after Casey versus Planned Parenthood, which is why it has special significance. And I'm not going to press the point about super precedent. I'm glad I didn't have to mention super duper that you did. Thank you very much. Let me come now to the statement you made in 1985 that the Constitution does not provide a basis for a woman's right to an abortion. Do you agree with that statement today, Judge Alito?
Well, that was a correct statement of what I thought in 1985 from my vantage point in 1985, and that was as a line attorney in the Department of Justice in the Reagan administration. Today, if the issue were to come before me, if I am fortunate enough to be confirmed and the issue were to come before me, the first question would be the question that we've been discussing, and that's the issue of stare decisis. And if the analysis were to get beyond that point, then I would approach the question with an open mind, and I would listen to the arguments. So you would approach it
with an open mind, notwithstanding your 1985 statement?
Absolutely, Senator. That was a statement that I made at a prior period of time when I was performing a different role. And as I said yesterday, when someone becomes a judge, you really have to put aside the things that you did as a lawyer at prior points in your legal career and think about legal issues the way a judge thinks about legal issues.
Well, Judge Alito, coming to the role you had in the Solicitor General's office, where you wrote the memorandum in the Thornburg case, urging restriction and ultimate appeal of Roe. That was in your capacity as an advocate.
Say 30.
And I have seen your other statements that the role of an advocate is different from the role of a judge. But when you made the statement that the Constitution did not provide for the right to an abortion, that was in a statement you made where you were looking to get a job, a promotion within the federal government. So there's a little difference between the 1985 statement and your advocacy role in the Thornburg Memorandum, isn't there?
Well, there is, Senator, and what I said was that was a true expression of my views at the time, the statement in the 1985 appointment form that I filled out. It was a statement that I made at a time when I was a line attorney in the Department of Justice. I'm not saying that I made this statement simply because I was advocating the administration's position, but that was the position that I held at the time, and that was the position of the administration.
And would you state your views, the difference as you see it between what you did as an advocate in the Solicitor General's office to what your responsibilities would be, or on the Third Circuit, or what they would be on the court if confirmed in a judicial capacity?
Well, an advocate has the goal of achieving the result that the client wants within the bounds of professional responsibility. That's what an advocate is supposed to do, and that's what I attempted to do during my years as an advocate for the federal government. Now, a judge doesn't have a client, as I said yesterday, and a judge doesn't have an agenda, and a judge has to follow the law. An important part of the law in this area, as we look at it in 2006, is the law of stare decisis.
Judge Alito, you have written some 361 opinions, and I'd like to have the time to discuss quite a few of them with you, but I'm only going to pick up one in the first round. And that is an opinion you wrote in the Elizabeth Blackwell Health Center for Women versus Nall. And that was a case where there was a challenge between a Pennsylvania statute which required as a prerequisite to a woman getting Medicaid that she would have had to have reported a rape or an incest to the police, and secondly, a requirement that there be a second opinion from a doctor that she needed an abortion to save her life. And that statutory requirement, those two provisions, conflicted with a regulation by the Department of Health and Human Services. And you were on the Third Circuit, which held that the Pennsylvania statute should be stricken in deference to the rule of the Health and Human Service Department. And Judge Nygaard entered a very forceful dissent saying that that this was an interpretive rule and it was inappropriate to have that kind of an interpretive rule by a department countervail a statute. What was your thinking in that case? Had you been predisposed to take a tough line on a woman's right to choose or on Medicaid support for someone who had been raped, you would have upheld the statute. What was your thinking in that case?
Well, what you said is correct, Senator. I cast the deciding vote there to strike down the Pennsylvania statute. And I did it because that's what I thought the law required. I thought the law required that we defer to the interpretation of the federal statute that had been made by the Department of Health and Human Services. If I had had an agenda to strike down to uphold any regulation of abortion that came up in any case that was presented to me, then I would have voted with Judge Nygaard in that case, and that would have turned the decision the other way. I've sat on 3 abortion cases on the Third Circuit. In one of them, that was the Casey case, I voted to uphold regulations of abortion, and in the other 2, the Elizabeth Blackwell case and Planned Parenthood versus Farmer, I voted to strike them down. And in each instance, I did it because that's what I thought the law required.
Judge Alito, I want to turn now to executive power and ask you first if you agree with the quotation from Justice Jackson's concurrence in the Youngstown steel seizure case about the evaluation of presidential power that I cited yesterday.
I do. I think it provides a very useful framework, and it has been used by the Supreme Court in a number of important subsequent cases. In the Dames and Moore case, for example, involving the release of the hostages from Iran. And it doesn't answer every question that comes up in this area, but it provides a very useful way of looking at them.
Do you agree with Justice O'Connor's statement, quoted frequently yesterday, from Hamdi that, quote, we have long since made clear that a state of war is not a blank check for the president when it comes to the rights of the nation's citizens, when she was citing the Youngstown case. Do you agree with that?
Absolutely. That's a very important principle. Our Constitution applies in times of peace and in times of war, and it protects the rights of Americans under all circumstances.
You made a speech at Pepperdine where you said, in commenting about the decision of the Supreme Court in Ex parte Milligan, that, quote, the Constitution applies even in an extreme emergency. The government made a, quote, broad and unwise argument that the Bill of Rights simply don't apply during wartime. Do you stand by that statement?
I certainly do, Senator. The Bill of Rights applies at all times, and it's particularly important that we adhere to the Bill of Rights in times of war and in times of national crisis, because that's when there's the greatest temptation to depart from them.
Steering clear, Judge Alito, of asking you how you would decide a specific case, I think it is very important to find out your jurisprudential approach in interpreting whether the September 14th, 2001 congressional resolution authorizing the use of force constituted congressional authorization for the National Security Agency to engage in electronic surveillance, where one party to the conversation was in the United States. Let me take just a moment to lay out the factual and legal considerations. The Foreign Intelligence Surveillance Act of 1978 provides, quote, it shall be the exclusive means by which electronic surveillance shall be conducted in the interpretation of domestic, wire, oral, and electronic communications may be conducted. The government contends that the Foreign Intelligence Surveillance Act clause, quote, except as authorized by statute, opens the door to interpreting that resolution to authorize the surveillance. Let me give you a series of questions. I don't like to put more than one on the table at a time, but I think they're necessary in this situation to give the structure as to where I'm going. First, in interpreting whether Congress intended to amend FISA by that resolution, would it be relevant that Attorney General Gonzalez said, we were advised that, quote, that was not something we could likely get, close quote. Second, if Congress had intended to amend FISA by the resolution, wouldn't Congress have specifically said so, as Congress did in passing the Patriot Act, giving the executive greater flexibility in using roving wiretaps? Third, in interpreting statutory construction on whether Congress intended to amend FISA by the resolution, what would the relevance be of rules of statutory construction that repeal or change by implication, that changes by or makes a repeal by implication or disfavored, and specific statutory language trumps more general pronouncements? How would you weigh and evaluate the President's war powers under Article 2 to engage in electronic surveillance with the warrant required by congressional authority under Article 1 in legislating under the Foreign Intelligence Surveillance Act? And let me start with the broader principles in approaching an issue as to whether the President would have Article 2 powers, inherent constitutional authority to conduct electronic surveillance without a wiretap, when you have the Foreign Intelligence Surveillance Act on the books, making that the exclusive means. What factors would you weigh in that format?
Well, probably the first consideration would be to evaluate the statutory question, and you outlined some of the factors and the issues that would arise in interpreting the statute. What is meant by the provision of FISA that you quoted regarding the FISA's, the Foreign Intelligence Surveillance Act, being the exclusive means for conducting surveillance. And then if, depending on how one worked through that statutory question, then I think one might look to Justice Jackson's framework. And he said that he divided cases in this area into three categories: where the president acts with explicit or implicit congressional approval, where the president acts and Congress has not expressed its view on the matter one way or the other, and the final category where the president exercises executive power and Congress, and that is in the face of an explicit or implicit congressional opposition to it. And depending on how one works through the statutory issue, then the case might fall into one of those three areas. But these questions that you pose are obviously very difficult and important and complicated questions that are quite likely to arise in litigation, perhaps before my own court or before the Supreme Court.
Before pursuing that further, we'll have a second round. I want to broach one other issue with you. My time is almost up. And that is in the memorandum you wrote back on February 5th, 1986, about the president's power to put a signing statement on to influence interpretation of the legislation. You wrote this: since the president's approval is just as important as that of the House or Senate, it seems to follow that the president's understanding of the bill should get just as important as that of Congress. Is that really true when you say the president's views are as important as Congress? The president can express his views by a veto, and then gives Congress the option of overriding a veto, which Congress does not have if the president makes a signing declaration and seeks to avoid the terms of the statute. And we have the authority from the Supreme Court that the president cannot impound funds, can't pick and choose on an appropriation. We have the line item veto case where the president cannot strike a provision even when authorized by Congress. Well, I've got 10 seconds left. I guess when my red light goes on, it doesn't affect you. You can respond. Care to comment?
I do, Senator. I think the most important part of the memo that you're referring to is a fairly big section that discusses theoretical problems, and it consists of a list of questions, and many of the questions are the questions that you've just raised. And in that memo, I said this is an unexplored area, and here are the theoretical questions that, and of course there are more than theoretical importance that arise in this area. That memo is labeled a rough first effort at stating the position of the administration. I was writing there on behalf of a working group that was looking into the question of implementing a decision that had already been made by the Attorney General to issue signing statements for the purpose of weighing in on the meaning of statutes. And in this memo, as I said, it was a rough first effort, and the biggest part of it, to my mind, was the statement, there are difficult theoretical interpretive questions here, and here they are. And had I followed up on it, and I don't believe I had the opportunity to pursue this issue further during my time in the Justice Department, it would have been necessary to explore all those questions.
Well, my red light went on. Senator Leahy.
Well, Judge, and good morning.
Good morning, Senator.
You survived yesterday. Listening to us, now we have a chance to listen to you. And that I'll have further questions on the memo that Senator Specter spoke of, but it gets beyond theoretical. I mean, the last few weeks we've seen well played out in the press where the President and Senator John McCain negotiated rather publicly an amendment which passed overwhelmingly in the House and the Senate outlawing the use of torture by United States officers. Yet the President, in his signing statement, implies that it will not apply to him or to those under his command, as Commander-in-Chief. Doesn't that get well beyond a theoretical issue there?
It is, and I think I said in answering the chairman that there are theoretical issues, but they have considerable practical importance. But the theoretical issues really have to be explored and resolved. I don't believe the Supreme Court has done that up to this point. I've not had occasion in my 15-plus years on the Third Circuit to come to grips with the question of what is the significance of a presidential signing statement in interpreting a statute.
Let me follow on sort of a related thing. In the Supreme Court, I feel one of the most important functions of the court is stop our government from intruding into Americans' privacy or our freedom, our personal decisions. In my state of Vermont, we value our privacy very, very much. I think most Americans do automatically, and many times they have to go to the courts to make sure that a government doesn't, whatever the government is, whatever administration might be, that they don't overreach in going into that privacy. Now, 3 years ago, the Office of Legal Counsel at the Justice Department, and you're familiar with that, you worked there years ago, they issued